We got our strange new order from the 11th Circuit. Does it support Judge Cannon in the Mar-a-Lago case and her decision to block Volume 2 about Mar-a-Lago from even going to congressional leaders? Or does it just ignore it for some reason? And what's going on at the 11th Circuit with the ultimate decision about whether Judge Cannon was right or wrong to dismiss the indictment in Mar-a-Lago against everybody by finding that the special counsel was invalidly and unconstitutionally appointed? First time in 249 years any judge has ever done that. Why haven't they made the ruling on that yet? I'll piece it all together right here. You'll make heads and tails of it when I'm done on this hot take on the MeidasTouch Network and Legal AF. I'm Michael Popok, and let's dive into this weirdo of an 11th, that's a legal term, of the 11th Circuit's decision issued by the clerk. Here's what happened. Judge Cannon in the last day or so, and I did a hot take on this, decided to revisit her original order. Her original order, 3 days ago, blocked the release of Volume 1 and Volume 2, even though Volume 1 of Special Counsel Jack Smith's report had nothing to do with Mar-a-Lago. It only had to do with the D.C. election interference case in front of Judge Chutkan. And Judge Chutkan wasn't blocking its release. Plus, all these cases have been dismissed against Donald Trump because, he won the presidency again, and that's what the Department of Justice did. But she blocked both for about 48 hours. Then there was a flurry of filings by all sides. Donald Trump got involved again, tried to intervene in the case, which is weird. You don't usually intervene in a case where your indictment's been dismissed unless you'd like to revive your indictment. And then the two co-conspirators for Donald Trump who work for Donald Trump currently, who are doing the blocking and tackling for Donald Trump at his behest because he's paying their lawyer fees, they started filing papers. They filed an emergency application with the 11th Circuit. They filed an emergency application with Judge Cannon. Stop the release of all the reports, even the reports that they are not technically a part of, like the D.C. election interference case, since they weren't co-conspirators there. And each of these two different courts, the 11th Circuit, which sits above Judge Cannon, and Judge Cannon, sort of moved at their own pace and slightly different spinning circles. The 11th Circuit said, let's have some briefing. We'll take a look at it. We'll let you know about whether Volume 1 or Volume 2 can be released. And Judge Cannon said, I'm blocking both from public disclosure. Then the Department of Justice weighed in both places and said, I don't know what everybody's so worried about. This is me paraphrasing the Department of Justice. They're not this informal when they write. I don't know what everybody's worried about. We're not going to release the Mar-a-Lago Volume 2 of Special Counsel Jack Smith's report because the Special Counsel doesn't even think that's an appropriate thing to do, has recommended that to the Department of Justice and Merrick Garland. He's agreed, we're not releasing it. At worst, the only place it's going is where it has to go by statute, under the special counsel law, which is to the ranking members of the House and the Senate, Democrat and Republican, who get a copy of the report, but only they have to keep it under lock and key. They can't keep a copy. They can't talk about a copy, and they can't disseminate a copy. But that's what the Attorney General has to do on the way out. The Attorney General, Merrick Garland, also left a love note for America and for his successor, probably Pam Bondi. And it went something like this. Again, my artist rendering. Dear Pam, it's in the public interest to release the Mar-a-Lago report. So if it's sitting on your desk the day you get confirmed, you should release it to the public. XXOO Merrick Garland. Something like that. But he's going to punt it over to her, and this will never see the light of day. The only way we may see Mar-a-Lago is if it ever does get past the Cannon block and ends up with the Democrats like Jamie Raskin and Dick Durbin, and we know about it through them. But hard copy of it, I'm not sure we're ever going to see that. In any event, we're still litigating over Mar-a-Lago. So the 11th Circuit, after hearing from Merrick Garland, Department of Justice people, that they weren't going to be releasing Volume 2 at all, which is the only one that's really involved with the 11th Circuit, the 11th Circuit said, okay, green light. I feel like I'm doing Squid Game. Green light. You can release Volume 1, right? And then, to continue the Squid Game analogy, Eileen Cannon, she had her own red light, green light game going on. And she said, green light on Volume 1 about D.C. election interference, of which she had no jurisdiction, but red light on Mar-a-Lago. And she wants a full briefing about Mar-a-Lago. which will time out on Thursday with a hearing in front of her up at Fort Pierce, Florida, with the lawyers who I guess are still Todd Blanche and John Sauer, even though they're going to be kicked upstairs to the administration soon. But right now, they're still working for Donald Trump privately. That's another problem. But she's going to have a hearing. Now we get the new ruling from the 11th Circuit. And I'm like, okay, here we go. They're going to chastise Eileen Cannon and say she doesn't have jurisdiction, and they're going to vacate all her orders. No. All right. They're going to say she was wrong about trying to block Volume 2 from going to Congress as permitted by the statute. Nope. Okay. So what you do, Popok, or what they do, through the clerk, so I don't even know which judge it was, they issued a half-a-page order that just said there's 5 pending motions in front of us. Emergency this, emergency this, emergency this, emergency this. All moot. Mootness. Why? What's mootness? Mootness means effectively that time, through the passage of time and new events, the dispute that was before the court has been resolved one way or the other. Something has happened. The rock has moved in the middle of the night, and therefore it is moot. We don't have to make a ruling about Volume 1 because Volume 1 is in the public domain. It's been published. Yay! Except that doesn't answer the question, because all of the motions and all of the motion practice was about Volume 1 and Volume 2, Mar-a-Lago. And they are strangely silent at the 11th Circuit about Volume 2. They don't even mention Volume 2 by name or by implication. They just say, we're done here. Nothing to see. 11th Circuit's done here. And that was it. Now, that means that they have either implicitly approved of how Judge Cannon is running her show and the jurisdiction that I don't believe she has to be making decisions about the Mar-a-Lago case any longer, since it's all up on appeal. If they are now basically endorsing and putting their stamp, their imprimatur of approval on Judge Cannon, it's really weird, because it's by effectively withdrawing all of their jurisdiction over this area and saying nothing to see here, they're leaving it to Judge Cannon to conduct this cockamamie kangaroo court, hearing on Thursday about whether she's got the federal power to order the block of red light of Volume 2 of Mar-a-Lago, not to the public, but to Congress. Have you or someone you know been a victim of identity theft, harassed, stalked, doxed? As people who follow our show know, I and the other hosts on this channel have been harassed and stalked, especially following the election. And that made me want to take control to protect myself and my loved ones. And that led me to our sponsor, Delete Me. Ever wonder how much of your personal data is out there on the internet for anyone to see? More than you think. Your name, contact info, social security number, and home address, even information about your family members, all being compiled by data brokers and sold online. Data brokers make a profit off of your data. Your data is just a commodity to them. Anyone on the web can buy your private details. This can lead to identity theft, phishing attempts, harassment, and unwanted spam calls. But now you can protect your privacy with Delete Me. As a person who exists publicly, especially as someone who shares my strong opinions, analysis, and commentary in online media, I'm hyper aware of safety and security, and it's easier than ever to find personal information about people online. All this data hanging out on the internet can have actual consequences in the real world. That's why I use Delete Me. Delete Me is a subscription service that removes your personal info from hundreds of data brokers. Sign up and provide Delete Me with exactly what information you want deleted, and their experts take it from there. Delete Me sends you regular, personalized privacy reports showing what info they found, where they found it, and what they removed. Delete Me isn't just a one-time service. Delete Me is always working for you, constantly monitoring and removing the personal information you don't want on the internet. To put it simply, Delete Me does all the hard work of wiping your and your family's personal information from data broker websites. Take control of your data and keep your private life private by signing up for Delete Me. now at a special discount for our listeners. Today, get 20% off your Delete Me plan when you go to joindeleteme.com/legalaf and use promo code legalaf at checkout. The only way to get 20% off is to go to joindeleteme.com/legalaf and enter code legalaf at checkout. That's joindeleteme.com/legalaf, code legalaf. The only thing I can assume is that they think that now, just on that discrete issue, Jack Smith should notice another appeal, wait for Thursday, see what Cannon does. Well, of course, we're running out of time here. I'll tell you why in a minute with the inauguration. But Thursday, when Cannon, let's say, continues to block, red light, the Mar-a-Lago report from Congress, then I think Congress should intervene. I think Jamie Raskin and Dick Durbin should intervene in the case and argue it for the ranking members of the Senate and the House. I think that's what the one thing should happen, with like an amicus brief, a friend of the court brief, lobbed in by Thursday. That's one. Two, I think Jack Smith could file a motion for reconsideration or rehearing to the 11th Circuit, asking them to clarify, a request for clarification about whether they're also saying that she was right on Volume 2. Or wait for Thursday to come and go with a bad ruling from Cannon, which is almost inevitable, and then appeal that immediately. They're probably working on the papers now to the 11th Circuit on an emergency application and try to get that done all before Monday's inauguration. You see the problem? We have another underlying problem. This is like the dog, the tail wagging the dog. The dog is the fact that the 11th Circuit continues to sit on the substantive appeal by the Department of Justice to try to clean up on aisle democracy the bad ruling by Judge Cannon about finding that the special counsel, and all special counsels by implication, is unconstitutionally appointed by the Attorney General as an inferior officer and unconstitutionally funded by Congress. That's a dumb ruling. It is unconstitutional how she's interpreted it. It's the first time in 249 years we had a judge do it, and she did not stumble upon the secret decoder ring to the Constitution, I assure you. But the 11th Circuit's been sitting on that for like 5-6 months. If they don't rule, and at the rate they've fallen in love with mootness, they could just sit on their hands and rule by not ruling. If they don't rule by Monday afternoon, Donald Trump, he's already prepared the paperwork. He's going to sign a pardon for the 2 co-conspirators in Mar-a-Lago, ending the case. Walt Nauta and Carlos de Oliveira, whether they wanted it or not, which we know they do, are going to get a pardon. That ends the case. The case is over, because in order for any court to operate and to have jurisdiction, there has to be what we refer to, it's a term of art, we refer to it as live case or controversy, which is sort of what it sounds like. You got to have a live dispute in front of you, not an advisory opinion. You can't like lob a request into a judge, federal judge especially, and say, hey, I got this property line dispute with my neighbor, and I'm not ready to sue him, but could you just tell me how you'd rule on this? No, we don't do that. And if parties disappear because they've been pardoned, case is over. Even if the 11th Circuit was just about to issue the order. I used this sports metaphor before. When you're at a basketball game and somebody, one of the players takes an amazing, beautiful Lago 3 shot right from half court, aiming for the basket. Here it goes. And it goes beautifully. Swish. Nothing but net. Nothing but the bottom of the net, 3-pointer, except there was a red lit box around the basket, and it's no basket. Time is up. Lid is on top of the basket. Same thing here. They might have had this beautifully written order ready to go that was going to chastise Eileen Cannon, was going to reverse her and set the world straight. But if they don't hit print or they don't hit publish before the pardons, it's as if it never existed. And we can't get a copy of it to answer questions in the chat. We can't get it by a Freedom of Information Act request. Nothing. That's why I started this hot take with saying we got a head scratcher of an 11th Circuit decision. Does this signal that they're not going to rule on the underlying merits of the appeal, and they're going to leave yet another bad precedent coming out of the Department of Justice against Donald Trump, which until there's a competing ruling by another federal judge or an appellate court, or the Supremes get to comment on it again, That's the only precedent in the area. Everybody will be citing it who want to get rid of their special counsel. See Eileen Cannon case of Trump versus U.S. or U.S. versus Trump. We can't have that. 11th Circuit, if you're listening. To my friends, that I know a couple of them, on the 11th Circuit in Atlanta, make your ruling, right? And make the right ruling. I guess that's what I'm trying to say. Make the right ruling. So until my next coverage of all things legal and political here on MeidasTouch Network on Legal AF, our 5-year running podcast, top 10 in the world. Hard to believe. All because of you. You're people powered. We're not, content powered. I mean, we are, but you're doing your part to help build this channel, this network. And now you've helped us get to 400,000 in 4 months of new subscribers over on the Legal AF channel. That's amazing. On our march to 500,000 by our half birthday. We're almost there, all because of you. Come on over, hit that blue subscribe button. Until my next reporting on all things Legal AF, I'm Michael Popok.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.